Hello and welcome to Climb's podcast series Advancing Vietnam with me Vlad Savin as your host. Throughout the following episodes, we're looking to answering relevant questions about doing business in Vietnam. What are the opportunities and challenges faced by investors entering the market or existing players in major industries? We will seek to understand the business environment from a cultural, local mindset and how to deal with compliance from an international perspective. What are the major risks faced by businesses active in the region and how to overcome them? We will dive deep into the compliance environment in Vietnam, discussing processes and procedures, changes in laws, latest official updates from the authorities, and financial governance planning for businesses active in Vietnam. We at the Climb consider compliance a major asset for foreign investors operating in Vietnam. We emphasize this aspect when speaking with our clients and we make sure they understand the significant benefits of being compliant. In this episode, I'm discussing with Matthew Lowry, managing partner at Climb Vietnam, about the key differences between foreign invested companies and representative offices in Vietnam, highlighting the benefits and risks for each of the structure with insights on market entry models into Vietnam. Matthew, welcome again to our Advancing Vietnam podcast series. There are a lot of misconceptions looking at the topic where investors are confused about the roles of these two different structures, the rep office and the LLC, which is the common market entry vehicle for Vietnam. They struggle to gain a deep understanding on how to actually assess which are the specific cases where they can use one of these two structures. So it will be interesting to find out your insights on this based on your experience.
Great to be here, and let's talk it through because it is confusing, misunderstood, and let's see if we can clarify and help out.
Let's then start with defining these two legal structures, the foreign-owned enterprise and the representative office of a foreign entity into Vietnam, and explain what are the permitted activities for each of those.
So simple company is a simpler structure. So a limited liability company is the simplest structure. It's the most common structure, and that is a corporate entity that is an income-earning entity in its own right. It can employ, earn income, subject to rules and operations of companies and as a taxpayer. It is permitted to undertake any activities it has a license to do so, which can be anything from providing professional services like ourselves. It could be real estate. It could be selling food in a shop. It could be retail, manufacturing. So companies have a broad range. You still must be licensed, but companies have a broad range of activities. A representative office is simply a location of a foreign enterprise in Vietnam. It's not an entity, it doesn't have legal structure, and it is represented by a chief rep to represent that in Vietnam. So it's a ability to have a presence in country. Its permissions are quite reduced in what it can do. It's there for liaison, market research, relationships, and there as a opportunity to interact with Vietnam, but it's not permitted to undertake commercial activities or support commercial activity. It's an outpost, it's not an operations. Just the key point is that it doesn't create a permanent establishment. And that's one of the key things with rep offices is that it allows have a presence in country without creating a permanent establishment because it's not generating income. A company, it removes a permanent establishment because it is an establishment in its own right. So for a foreign investor, just understanding what they are is important. So
and that could be one of the benefits as well of having a rep office. We'll talk about that later.
It's one of the protections and why you do rep office is it removes a permanent establishment risk if you follow the permitted activities, where a company, again, removes it because it's a tax-paying entity in its own right. So foreign investors coming in need to understand what they want and what those structures provide.
And at the core, these two structures are fundamentally different. How is that?
One is there for generate profits and one is there to not, or support profit generations. Now people go sometimes with that oh no, we're not generating income, Vietnam's only looking after the operations of a foreign enterprise. The argument there, and it used to work pre-2016, is that the support of income earning activities is not permitted at rep office. That's what a company is supposed to do, or another entity in Vietnam, a subcontracted entity, because simply supervising and supporting a contract signed by a foreign party is generating income. It's part of the income generation process, and that part of having someone to QC, being part of a factory design and development process is adding value and generating part of that income in Vietnam. So that's where rep office cannot do an activity because it's income support, it's commercial activities. So just on that, rep office is permitted to act as representative office in Vietnam for Vietnam, to provide activities in market relating to market research, business development, liaison, etc. It is not there to support domestic consumption activities or create a value. Whether you export those services or products or use it domestically, it just can't produce that income, can't support income producing activities at all, because it's for Vietnam activities, and you can't do any income producing activities whilst in Vietnam, the rep office.
Let's take a step back and look at the process for setting up these two structures, the foreign-owned company and the representative office, and how long do they take, each of them?
Even though representative office is a simpler structure, it doesn't create a corporate enterprise, there's no tax obligations, it actually takes longer in practice. So company's simpler. LLC, limited liability company, takes statutory periods of 4 to 5 weeks and statutory period for setting up the company. That's 2 stages. It's the IRC foreign investment approval process, and then there's ERC company registration. So that's 4 weeks, in practice 5 weeks. Couple of weeks, 2 to 3 weeks in foreign countries to get the documents legalized, to be accepted. So if you work backwards, the journey is maybe 8 weeks to get a company set up. You need copies of charter, memorandum articles, certificate of incorporation, passports of investors, but the company can be brand new. The parent company, the investor company, can be a brand new enterprise. There's no requirements. A rep office, the parent company must have been established more than a year. You need audited financial statements or tax finalization documents, and it must be within a 6-month period as well. So you can often have a window where you can't do the registration. And then it's a period of takes around 5 weeks to 6 weeks in country, sometimes longer, to get the representative office registration completed. Mm-hmm. So your journey is documentation and then lodgement with the authorities, about 10 to 12 weeks in practice for a representative office, where for a company, it is usually that 6-8 weeks on average, with practically less documents required. Just from an authority point of view, you've got one authority with a company DPI, but you've got a number of lodgements, provided no restricted activities, where you've got one lodgement with the rep office. It goes straight to the Department of Industry and Trade, and it's a single lodgement. So even though it takes longer, it is one lodgement.
As you touched on before about the 2016, in 10th of March 2016, the authorities changed the way the representative office work and what they were allowed to do. And from that moment,
Decree 7, yes.
Decree 7. Can you share a bit more about how did that impact the representative offices that were already established, and what happened since the moment forward?
So Decree 7 in early 2016 removed the permitted activity of rep office to support commercial operations of the parent. So prior to that, there was the permitted activity to support those operations. That was removed. So any new licenses issued after that Decree 7 in 2016 were not allowed to have that permitted activity to support. So prior to 2016, it was a common structure where you'd have staff in Vietnam with the rep office supporting contract between a foreign company and a Vietnamese manufacturer, for example, and they would do the support activities to support that contract, be it supervision, be it inspection, design, helping with distribution, whatever that might be. From that date, any new licenses were not permitted to be involved in those income-producing activities. They could help negotiate the initial contract as a representative, and then they would have to step out. So the Vietnamese staff were not allowed, Vietnamese-based staff. What you had for those who were transitioning, they were still allowed to complete their activities. If they were licensed and had a license prior to that, and there was on their license, they could continue until the next renewal. And in the next renewal, they were supposed to have that removed from the activity. I have seen examples where it wasn't removed, which is fine, but the idea was that after every 5 years, you must renew your license. Any renewals would no longer have that permission. So we saw quite a few representative offices. There was one next to us in a building, a German group who were trading for many years under a representative office. Post 2016, they then incorporated a limited liability company to run beside their representative office to support their commercial activities in Vietnam. So they kept both, and that's what fundamentally happened after 2016.
And one of the misconceptions that we often hear from international investors is that the market entry process somehow appears to be simple and more efficient if you set up first a rep office and then you convert it into an LLC later, thus making it potentially faster, cheaper, and easier. Is that something that matches reality?
Yeah, it's an interesting concept that I see pushed regularly through sort of promotion websites, etc. Not the reality though. they're different laws, they're different ministries, they're different everything, and there's no conversion process. And to make it harder, if you wanted a rep office and then you wanted an LLC, you cannot be both the chief rep and the head of the head of the limited LLC. You can't have both capacities at the same time. So that presents a structural problem in how do I progress across if you've got one person is the head of the business. So it's an interesting one. So there's no path, and in fact, you are starting. If you decide that you need a corporate entity because you need to support activities or generate income in country, therefore you need to start the process again for an LLC. And concurrently having both is possible, but you need at least two different people with authority, one for the rep office, one for the company. And you will need that because you need to start the company first. And then if you want to close the rep office, it takes time to close a structure down. There's not a transition process whatsoever.
Mm-hmm. You mentioned before LLCs, as we know, is one of the most common market entry vehicles used for international investors. Then how does the rep office make sense for a strategy of a foreign investor for the market entry? Do you have a couple of case studies?
Yes, it's less a role than it was pre-2016, but it is still definitely a role. So we see that. So with a good example of a client we have, which is US agricultural supplies. They have a Vietnamese distributor based in the north, and that distributor is responsible, it's a local company responsible for a number of their products in market. That US company also has a representative office in the south. The representative office's role is to monitor the market, monitor how the products are perceived, monitor the marketing, monitor opportunity, report back to headquarters in the US about their observations, recommendations, and new products or changes to products. So they are keeping an eye on the market, they're liaising, they're doing business development, they're doing the activities.
But they're not involved at all with the LLC.
So the US company deals direct with the distributor, the products, how they come in, what the pricings are, is between the distributor and the US company. So the US company is completely responsible for all negotiations, etc. The representative office is the eyes and ears of that US company in Vietnam. Another example, you might have some variations of that. So we've helped some foreign governments do their trade promotion office, which is a presence here which allows them to promote their country and their particular products, and it gives them a right to be here, a presence. We've helped foreign airlines create a foreign ticketing office, which is a form of representative office, allowing them to have a point of presence, employ staff and liaise with regard to their services. So there's a whole range of these that allow businesses to do what they want to do within having an access to Vietnam, having a relationship and monitor it and go forward. There's others like some of the large US multinationals, I won't name them, but they operate on a two-stage structure. They have their operating businesses here. Then they have the rep office, which is a branch of the headquarters, which keeps in oversight on the brand positioning, on how they're perceived, and government liaison. And a lot of them, large ones, want to have a government liaison as well, which is separated from production and is more focused on their parent company's ideals other than not their manufacturing and distribution arms. So that's also a very common way to operate.
Mm-hmm. And what happens when international investors that have already a rep office in Vietnam and they operate outside the limits of the permitted activities that are actually listed within the certificate of the rep office? What are the risks for going ahead with these activities on the long term and for the chief representative potentially as well? So
the issue with doing things outside of the permitted activities is that the authorities can deem non-compliant, and the tax authorities can deem there to be a permanent establishment in country, which means that the foreign entity, because the rep office is not an entity, is deemed to be trading, and therefore a part of their revenue is attributable to Vietnam and taxable in Vietnam. And it's creating operations. So the funny thing with that is your taxable income, you would not have any allowable deductions because you're not VAT registered and no corporate income tax deduction. So there's a whole world of pain in that case. And it's got to be careful. Now, the other part about the chief rep is the chief rep represents, and if they wanted to deem the chief rep to be in receipt of income or to be earning income on behalf of the permanent establishment possible, and also not any expenses that are outside the permitted activities would be deemed a personal benefit to the chief rep. So who becomes liable personally for taxation in respect to the activities, or the parent company can be taxed and treated as a taxpayer in country as well. So you've got this exposure there where it can be quite difficult. There's penalties as well. In practice, the authorities, if they inspect and find, generally, depending on the nature, they generally, if it's an inadvertent or it's something that's evolved over time, we have seen the authorities on inspection come in and say, hey, you need to change, fix it, or we'll take further action. And we've seen them be quite pragmatic about setting up a limited liability company and transitioning across. We've seen that. We've also seen ones where they have not, and they've issued penalties and gone further. So it's a bit of a mixed bag.
Let's clarify a bit more about the revenue generating activities, because we've heard from different types of entities in Vietnam, mixed opinions about this. And it's important to understand if the rep office supports generating activities outside Vietnam. Is that compliant in a sense, or how would any revenue be generated within the rep office?
So a rep office, first thing is, rep office is set up to undertake activities in Vietnam for Vietnam. So by doing things that are supporting outside Vietnam, you're outside the terms of a rep office. It's rep office. It's the Vietnam representative office for the Vietnamese activities. The second thing is it has explicit exclusion under the rule about supporting income generating activities in Vietnam. So your first funnel is the activity related to Vietnam? If you're supporting outside activities, you're in breach. And also you can't do any commercial activities whilst in Vietnam. So there is no ability of a representative office to support income activities. It is explicitly for, you can only undertake permitted activities which are listed, which is liaison, market research, promotion, those sort of activities. There is no permission for and exclusions for supporting commercial activities or activities outside Vietnam. And that's written in the rules. In fact, just on that, we actually saw a recent, and I don't know if you saw it, but there was a recent representative office certificate issued that had in bold, highlighting that fact they could not do the activities that the parent company was doing. They were not permitted to do so. And just to highlight that they're only allowed to do those activities in Vietnam, that was specifically stated. And they bolded what they could not do.
And going back to taxation that you mentioned before, in 2016 as well, the authorities released an official letter looking at a specific case on taxation for rep offices and the implications for deeming a rep office a permanent establishment in Vietnam.
Yeah, there was I think it was a Russian entity that there was a case, and they deemed, because they were supporting activities, and this is pre-2016, they had the ability to support commercial activities, but the nature of they were running a business in Vietnam, and they were deemed to be running a business and generating activities, and they were deemed to have a permanent establishment. The parent company was issued tax notices in respect of their worldwide activities in relation to what the authorities deemed, and it's a deeming provision, to be generated and earned in Vietnam. And they've done that. So this idea, even though they didn't take a light touch, there is precedent that the authorities will deem a permanent establishment, and that case was, they still had the ability on their license to support commercial activities, but they're well outside the scope. So by not having the ability, you are definitely exposed to the tax authorities deeming your permanent establishment if you're undertaking or supporting commercial activities in a rep office. Rep office is not there for commercial activities. And the authorities, tax office has precedent to deem the foreign parent company to be taxable. As I said, you don't want that because you don't get the deductions. You get the income taxable. It's the worst of both worlds.
And from a statutory perspective, companies in Vietnam are represented by a key person, which is called the legal representative, and the rep offices are represented under the law by the chief representative. What are the key differences between these two statutory positions and risks attached to them?
So let's start with a company. A company has a legal representative. A company in Vietnam, unlike common law countries, does not have individual capacity. It can't itself be deemed to be doing something. It needs someone to do that for it, which is the legal representative. So if you're entering a contract, represented by, a bank account, represented by, the individual is providing capacity for the company to do something. If you're going to sue the company, you sue it through the individual representing the company. You can have, under the laws when they changed in 2015, you can have as many legal reps as you want. One must be resident in Vietnam or generally reside in Vietnam, but you're unlimited by number. And under the most recent enterprise law, they have joint and several liability. So each legal rep is equally liable unless the charter says otherwise. I don't believe there's any court precedents to determine whether that will stand or whether the default joint and several liability will override if the authorities deem. So you have a liability because you can be indemnified out of the assets, but you are party to whatever happens. And if there's illegal activities or lawsuits, there is personal risk on behalf of the company, but it's done through an individual. A chief rep is not that different in many ways, but a chief rep is representative of the office, not an entity. And that's that subtle difference. It's of the office only, because the office can only employ staff and incur costs in relation to administrative, your rent, transportation, office stationery, promotion activities. So there's less that can go through, therefore less liability in theory, unless you're outside your scope. And you can only have one chief rep. They don't have to reside in Vietnam. If they're outside, they are supposed to appoint a power of attorney for someone in Vietnam, but they do not need to reside. And the laws are, as I said earlier, I mentioned that you can't be chief rep and legal rep at the same time. It's one or the other. So they're different laws, they're different ministries, they're different elements. They both have liability in respect to the actions being taken by the vehicle, by either the representative office or the company. But because the activities are less of a chief rep, of representative office, there is less liability for a chief rep. The only subtle difference there, if you wind up a company, the tax office will inspect the company and the company may be penalised and the investors, and you run through that process. If you wind up a rep office and issues, they will actually deem the chief rep to be doing things wrong, and they will actually ask the chief rep to, because there's no structure. It's just an office, so the structure, they go after the chief rep. So the chief rep may be penalised on behalf of the company, but the chief rep will be the challenge, versus a legal rep, it's generally the shareholders and it's the company itself. So it's subtle but important difference.
And winding up the rep office is as well more cumbersome, takes a long, more time.
They both take a long time. They both require tax clearance. The difference rep office is it doesn't have any tax obligations other than personal income taxes during the year. So there's no, you can go for the entire life of rep office never having seen a tax man. He comes in, you're exposed, versus a company should be compliant invoices as it goes. And it's inspections on a regular basis for most companies. That a company is a tax-paying structure, therefore it's process procedure. Representative office does not have any tax liabilities, but if you don't follow the rules, the tax office can deem. So it's not to take longer, it's just a different process and a different level of potential exposure, because if you're not prepared, you can have trouble.
And what advice would you give to an international investor that is looking to enter Vietnam and they have these two options on the table, LLC and the rep office? How should they approach this market entry strategy to ensure that they have the right vehicle for their business? What are the key areas that they should understand and apply?
If you're running a business in Vietnam or supporting operations, then a rep office does not work. A company is the default. If you are needing to support activities, the general rule is a cost plus. So if you've got a factory contract and you want a bunch of people on the ground to help design products and help support the factory, help support the exports, but not touch them, what you have is a cost plus structure for a company. So if you've got $10,000 a month in salaries and $5,000 a month in costs, you got $15,000, you would charge that back to headquarters plus a margin, and you would invoice them every month for your costs plus margin, and you make a profit in country. A company is expected to make profit. That's the purpose of why you have a company, is to run a business and make profit. So the company structure allows you then, those employees are providing commercial services for the parent company, can go to the factories, help out, do their things and work out. That's a legitimate way to do things. That's not what you can do in a rep office. So if there's commercial activities, where a rep office works is you want to keep an eye on the market. You have products in the market, the third-party suppliers, or you're looking to enter the market, or someone else has licensed your brand, you want an idea, or you're looking to create relationships and government liaisons and need someone in country that can help push the agenda. So when you're ready, so maybe the market, your product's not suited for market, but it's going to be. It's one of these, like I've seen it, for example, for hemp products. Hemp is not generally in Vietnam, not permitted. There's a lot of things from medicinal to herbal to clothing to food and beverages. Is that a market you would have a rep office to see when it's ready to enter, and therefore, but you've got no products yet? So there's a whole range of reasons you could have a rep office, but it is about liaison and research, not about activities. So as soon as you have a large number of staff, as soon as you're servicing foreign parties, as soon as you're doing products, you've really got to sort of look at the LLC, because the limited liability company, because the rep office, just you're outside scope. And because it is not, representative office does not pay taxes, not in the tax system, you've got to think, if you are deriving income from the activities, there's the problem.
Matthew, thank you again for this wonderful insights. Hopefully our listeners and our viewers on YouTube gain some understanding on ensuring that they are compliant with either vehicle they choose, and they're understanding exactly how they can use it and what are permitted activities. And I think this is of critical importance to start your market entry process right from the beginning. So thank you again for sharing your
Great to talk, and look forward to the next discussion, but hopefully this was helpful for everyone out there.
Changes from March 2016 removed the ability for representative offices to monitor and promote the performance of contracts signed with Vietnamese partners or those related to Vietnamese market on behalf of its foreign parent. The effect of the above is that the representative offices are not permitted to engage in commercial activities or support their parent entity with commercial activities in Vietnam. There are many cases where the registration of a rep office in Vietnam is the right approach for a market entry strategy. However, investors should peruse the legal frameworks presented by Law of Enterprise, Law of Investment, and Law on Tax Administration to gain a complete understanding on what they are allowed and not allowed to do in the market. And many thanks to you, our listeners, for tuning in to Advancing Vietnam podcast series. For more information about this topic, please check out our publications on vietnam.compliane.com. And if you want to reach out to us for any additional details, feel free to contact me on LinkedIn or throughout the website contact details.